Today, let's talk about agency. Why is agency important to you as an MBA student and a future manager of a business, perhaps owner of a business? Because everyone that works for you or represents you is your agent in most cases. And you can have legal liability for things that your agents do on your behalf. So let's talk about agents, all the various characteristics of an agency, what an agency is. Um, Basically, you can see a definition here. Basically, someone has a duty to act on your behalf, and you've consented for them to act on your behalf. This could be, as you see, an employer, employee, to a certain extent, independent contractors, your sales representatives, your distributors, just a number of people that work on your behalf, directly or indirectly, can be agents. Now, one thing that you need to be wary of is you could be liable for what your agents do. Some of you might recall this cruise ship, the Costa Concordia. Pardon my poor Italian, but it was the captain essentially went too close to shore to show off and was waving, and he capsized this cruise ship, killed 32 people, and let's see, they said it's going to cost over $2 billion with a B dollars to Carnival, who owned the ship, for this one guy's mistakes. I think that's a generous way to say it. But you ought to say, wait a minute, he did things that he shouldn't have done. Well, largely, I'm going to tell you the rule and an acceptance to the rule. Largely, let's say you own Carnival Cruise Lines, okay? So for purposes of this lecture, you own Carnival Cruise Lines. Well, you're going to be responsible for what your employees do, stupid or not stupid. You often have to end up paying for it. So let's talk about agencies, what they can do, what agents, what they can and can't do, etc. As we stated before, included within agencies are employer-employee relationships. Okay, there is a distinction between what's known as an independent contractor. You may have worked for somebody who basically said, I don't want to pay your wages, so let's call you an independent contractor. You're really not my employee. A little bit later, we'll talk about whether you can do that or not under the law. Well, consequences of having an employee or being an employee. Well, your employer, you, Carnival Cruise Lines, you're employing me. Well, you have to pay taxes. All my employer's portion of FICA, the employer's tax on that employee. You got to pay for workers' compensation, unemployment tax, etc. You're also often liable for things I do on the job. Now, how does a court determine whether I am your employee on the cruise line or I'm an independent contractor? Well, you're going to say, well, I'm just going to have a contract that says that Kevin is an independent contractor. Not so quick. The law can see past that and says there's actually a test. And these are the type of factual issues we're going to look into to determine whether Kevin was your employee or whether he was an independent contractor. Did you have control over me? Do I work for any other cruise line or only for you? Do I do it under your manager's direction? Do you give me the tools to work at Carnival Cruise Line? Am I employed for a year, for example? Do you pay me directly? These are the type of things that a court would look at to say, wait a minute, you can call him an independent contractor, but you're not going to be able to escape liability for the dumb things Kevin does, nor liability for his taxes if he really is an employee. Let's watch a video real quickly about this test. It outlines one law of one state's as an example of their test.
In this video, I'm going to give you the 8-prong test to determine if you're an employee or an independent contractor. My name is Matt Eason. I'm an employment attorney in Sacramento, and I've represented hundreds of employees in questions just like this. And to determine if you're entitled to overtime, meal breaks, rest breaks, things of that nature, it's important to know if you're properly classified as an employee versus an independent contractor. And in this video, we're going to walk through the steps on exactly how to make that determination. Before we get into the 8 factors, I want to make sure we understand the big picture, and that is control. All these factors in some way have to do with who's in control of the relationship, who controls the product, who controls the way things get done, and the mechanisms and the mannerisms. So when you go through the factors, think of control. The first factor is, do you have your own independent business, or is this the only person you work for? For example, if you have a cleaning service and you work exclusively for one person, then you're most likely going to be an employee. Contrast that with if you work for different people on different days or different projects, you're most likely going to be an independent contractor. The second factor we want to look at are your employer's primary business purpose. If we look at the same example that we use on the janitorial, if your person that you're working for is a janitorial service and you're performing janitorial services for them, you're most likely an employee. Contrast that if the employer is an auto parts dealership and you come in one day a week to perform janitorial services, then you're most likely an independent contractor. The third factor we look at is who provides the instrumentality or the tools. Who has the equipment that you use to perform your services? If the employer is providing you all the materials and all the equipment, they're probably an employer. On the alternative, if you bring your own tools, you bring your own equipment, that tends to lead to suggesting that you're an independent contractor. The fourth factor has to do with a specialized skill. Is there something about your knowledge base and your skill that you bring an extra benefit to the employer that the employer may not know? And if so, you're most likely going to be an independent contractor. In contrast, if the person you're working for has the same skill sets as you or greater skill sets as you in the subject area, you're most likely going to be an employee. The fifth factor that we look at has to do with efficiency. If you are able to work harder, faster, and smarter, and you personally benefit from that, then you might be an independent contractor. But if you work harder, smarter, and faster, and you don't receive any special benefit from that, it all goes to your employer, then you're most likely an employee. The sixth factor we look at has to do with duration of employment. If the assignment is such that you're going to work for an indefinite period of time, you're most likely an employee. If you contrast that with a situation where you're hired for a limited period of time, 1 month, 2 weeks, or for a certain project, then you're most likely to be an independent contractor. A seventh factor really important in determining the relationship is how you're paid. If you are paid by the job or by the project, then you're most likely going to be an independent contractor. If you're paid by the hour or on a weekly or periodic basis, you're most likely an employee. The eighth factor we look at has to do with how you treat the relationship with your employer. If the two of you treat one another like an employer and employee, then you're probably an employer-employee. If you have a more distant relationship, a more hands-off supervisor relationship, then you're probably an independent contractor. We just went through 8 important factors and determined if you're an
All right, so you've seen a basically control test on whether someone is your agent or not. In this instance, an employee type of agent. IRS and your state workers' compensation board that requires you to have workers' compensation insurance over your employees but not independent contractors will also look at these type of tests and ensure that you as an employer are not trying to get around it and avoid that liability and save money. And you could have some penalties and some serious problems and some instances personally, not just your company, if you don't pay the appropriate taxes for your employees. Work for hire, I'll let you read that. That's pretty straightforward. Now, agency agreement. And so now let's talk about not just employees, but your distributor, your sales representative. So you own Carnival Cruise Lines, but you hire salespeople to sell at major trade shows or to make cold calls or do such and such. Are they your agent or are they your employee? Well, an agency can be formed. Let's just say agent, and let's not say employee, but them becoming your agent, that agency by agreement can be written or it can be oral. You agreed to let me be your agent. It can be by ratification. I go out and tell 1,000 people about come sail on your cruise line, and then you accept them and then pay me amount. Well, you've ratified me being an agent. And let's look at agency by agreement versus agency by ratification.
No medical exams on policies under 1 million.
A friend recommended getting life insurance through Ethos.
In this video, we will discuss agency by ratification. An agent is someone with legal authority to act, at least in some ways, on behalf of someone else. The party for whom the agent acts is called the principal. So let's say Patty is a singer, and on Monday she gives Alan Agent the authority to sign performance contracts on her behalf. On Tuesday, Alan meets with a promoter who offers $100,000 for Patty to sing at a concert. Alan agrees that this is a good deal, and he signs the performance contract for Patty. Alan signed the contract because Patty gave him the authority to sign contracts as her agent. Remember, on Monday, Patty gave Alan authority to sign contracts on her behalf. On Tuesday, he acted with authority to sign the performance contract. But now let's change the story. Alan hears his friend Patty sing at a karaoke bar, and he's moved to tears. He plays a tape of Patty singing for a concert promoter, and the promoter is also moved to tears. The promoter offers a $100,000 contract, and Alan signs the contract on behalf of Patty. The next day, Alan sees Patty and says, "Hey, surprise! I signed a contract for you to sing at a concert." Patty is furious. She tells Alan that she's not going to sing at any concert and that Alan had no right to sign for her. And Patty's right. She doesn't have to sing at the concert because Alan acted without authority. So Alan says, "Sorry, I thought you'd want to sing, and besides, they want to give you all this money." Patty reconsiders and decides to accept the money. Now Patty is obligated to sing at the concert. Although at the time Alan acted without authority, Patty subsequently ratified what Alan did. The relationship between Alan and Patty now is agency by ratification. Under the law, it is as though Alan was Patty's agent at the time he signed the contract.
Okay, now you see agency by agreement versus agency by ratification. Ratification just means after the fact. Yeah, what they did I agree with. You can create agency by estoppel, like, hey, I allowed you to do something, and so you've got the benefit. The law says, wait a minute, you can't now say he didn't have it. So I kind of came up with an example here. You, student, want to sell your house. You allow me, real estate agent, to represent. I'm your agent. I go out and I find a buyer, and I tell the buyer, yeah, I'm their agent. And so he goes out and borrows money and goes to purchase the home. Now, the buyer, can rely on my representation that I am your agent and I can arrange the sale of the house if you've permitted me to do so, or if you ratify that after the fact, okay? Even though we haven't had a formal contract. Estoppel is this person that's going to buy the house had to be reasonable. Now, if I went to somebody and said, hey, I'm going to sell NSU student's house for $10, that wouldn't be reasonable for them to say, I have a right to enforce that house sale contract, does it? No. So reliance must be reasonable. There also you can also establish agency. I'm your agent by operation of law. Those are relatively limited circumstances, but the law sometimes says, my significant other goes in and buys groceries. Well, the grocery store can reasonably consider that my spouse has the authority to buy for me and that I owe it. So that's usually reasonable. Emergencies, somebody arranges for medical treatment. Theoretically, the person that arranged for the medical treatment to be done could be liable. considered an agent of the individual. Now, what are the duties? Agent and principal. Why do we use the term principal? Well, principal is, in your instance, you're the company, you're the cruise company, and people that work for you are your agents. Just, I guess the best metaphor way to remember it is at school, who's in charge? The principal. Well, in this transaction arrangement, you're in charge. You're the cruise company. You own the cruise company. You're the principal, and I'm your agent. I'm working for you. I might be called an employee. I might be called a distributor, a sales representative, an agent. I might be called a number of things, but in each of these instances, I'm a type of agent, okay? So what duties do I have to you if I'm your agent? Well, I have to use reasonable diligence and skill. In other words, I have to perform in an acceptable way, or I breached my contract to you. Second, I have to give you notice if anything that's material or important about the relationship and about our company. I find out somebody's stolen our files and now they're using our files for competing business. I have a duty to let you know. That's part of my duties, because as an agent, I'm entrusted with your best interests. I have to watch out for your best interests. Now, additionally, I have a duty of loyalty. I can't go be working, unless you know and consent, I can't be working for, let's say, we said you're Carnival Cruise Lines. I can't be working for you and Princess Cruises or Viking Cruises at the same time unless you consent. Now, if I'm working just for you generally, that's the case. But in some instances, let's say a travel agent, they might be authorized to sell cruises from your competitors or you. So you can see there could be two different types of agents. But generally, I owe you the duty of loyalty and not to compete. I also have a duty to maintain confidentiality and not to disclose your confidential proprietary information to anyone unless authorized. I must be loyal. I can't go out and sell. I'm going to go out and sell packages. You've got cruises to Italy and Greece. They're, $5,000. I can't go out and sell those and then keep the money. I've got to and start my own cruise company. No, I'm loyal to you. I'm working on your behalf. Also, obedience. I have a duty to follow your directions and how you want business run. I have to give you an accounting, what monies I've received, what I passed along, etc. Now, what, as the principal, you, student, owner of the cruise line, what duties do you owe me? You have to pay me. Whatever we agreed, you owe me for my services, right? You have to reimburse me or indemnify me. So, excuse me. So if I fly to California and sell, 500 tours, then you have a duty not only to pay me my commission on those 500s, but you generally have a duty to reimburse me for my travel expenses and et cetera, et cetera. Now, the contract can vary that, but that's a general duty. Also, if I've done something that we get sued for, but I was doing what I was authorized to do, then you usually have a duty to defend me in that trial and to make me whole if I've done what you've asked me to do. You also have to cooperate with me. You have to give me sufficient information and tools to do my job. If I'm an employee, you have to give me safe working conditions. You can't just put me in a plant that, has open fires or, hazards all over. That's a duty you owe me as an agent. So you see the duties and the remedies I have against you. If there's a problem, I'll let you read through those. If I violate my duties to you, that could be a contract and or a tort that I've committed against you. I might engage in misrepresenting something and being negligent in the way I've done something, libel, slander. And theoretically, not only could you sue me, but that would give you just cause or a a defensible cause for terminating me as an agent. Not taking my life, but terminating my agency. Let's be clear about that. Indemnification, I'm going to let you read through that. All right, let's jump on. Now let's say who's liable. Let's talk about what authority I have and you being liable for what I do, okay? So I go out on your behalf and I sell and I'm driving a car, I might run into somebody, etc. How liable are you as the principal for the things I do? Well, you might ask, what is my authority? Was I doing something outside my authority, or did I have authority to do what I did? All right? Actual authority means you said, you can do ABC, Kevin. You're my agent. Apparent authority, is you allow me for 3 years to go out and sell and say A, B, C, D, E to the clients. You didn't stop me and you knew what I was saying. Well, I apparently have the authority to say what I do because it was reasonable for these customers to rely on me as your representative, your agent. So let's watch a video real quickly about actual authority, implied authority, and apparent authority, 3 different types of an agent's authority.
So there is one secret investment that no one seems to know about. It's not stocks, it's not cryptocurrency.
So when is a business bound by or obligated by the agreements or contractual relationships entered into by the business's agents or employees? Well, the answer to that question depends on the concept of authority. So when an individual represents a business, okay, when the employee goes out and undertakes any activity on behalf of the business, they are representing the business in that fashion. So they are acting under some type of authority. Okay, the first authority is actual authority. That is the amount of authority expressly granted to the employee or agent by the business. Okay, so you have an employment contract that describes the job that the employee is to do or outlines specific tasks or functions that the employee is going to undertake. Well, in that case, that would be the actual authority, the authority granted to the employee by the business. Now, a related concept is implied authority. This is authority that the agent or employee has, but it's not expressed, it's not written or put out to the world that the employee has this level of authority. Rather, it's implied from any number of things that exist in the employee-employer relationship. For example, say an employee has the title of President of Operations. Well, it is implied from that title, from the employee's name in the business, their title, that they can undertake certain tasks. A president of operations would be able to undertake anything, any contractual agreements related to operations. Now, it would be reasonable for an outside person dealing with this employee to enter into a contract and expect that that employee or agent has that level of authority. So that level of authority is, again, implied. Authority can also be implied from some level of past dealing or course of performance with the business, or a third party's awareness that this employee or agent has acted in a certain manner with other suppliers or other third parties interacting with the business. Let me give you an example. I'm an employee of the business, and I approach a third party about purchasing some supplies for the business, a large supply contract. Well, if we had prior dealings and I represented the business and the supplier entered into this type of agreement with me before, it would be reasonable for them to believe that I had that authority. So from our past course of dealing, that even if I don't have that authority, it could be implied. I don't have that express authority. It could be implied from our prior course of dealing that I have this level of authority and can enter into this agreement. Okay. It could also be the situation where this supplier has or is aware or has received information that I've entered into a similar type of deal or transaction with another third party, with another vendor or supplier. In that case, again, it would be reasonable for them to believe that I have that level of authority, and it would be implied from that course of dealing. Okay? Now, and then the last one is apparent authority. Apparent authority is when I express to a third party, okay, as the employer agent, I express to a third party that I do indeed have this level of authority. And given whatever circumstances exist, it is reasonable for that third party to believe me, to believe that I have that level of authority to transact business or enter into an agreement on behalf of the business. So those are the three situations where the business will be liable for or bound by, obligated by, the agreement entered into by the employee or agent under actual authority, implied authority, or apparent authority.
Okay, I think that well describes those three different types, how authority can be granted, if you will, or more likely respected or recognized by the law. We can go through these. We just saw those. Let's give an example of express authority. Power of attorney. I don't know if any of you run across that, but sometimes, let's say grandma is incapable of, running out to the grocery store, or she's starting to get to the point where she has early, God forbid, early onset Alzheimer's or dementia or something like that, and she just can't handle her finances. Well, before she really has a serious mental decline, she might give you a power of authority that says, grandson, granddaughter, so-and-so MBA student has power of authority to write checks and to pay my my bills, etc. Well, that's a type of a power of authority. You're an agent of your grandmother, and you can, have just a limited power of authority that ends at a certain time. You can have a broad power of authority that you can do almost anything. It depends on what's granted to you. And of course, if the principal passes away, that usually ends the power of attorney. Let's see. We talked about apparent authority already. Ratification we talked about, that even though you might have not asked me to be the singer, remember the singer, initially to be your agent, you might later ratify it, say, okay, he was authorized to act as my agent. All right, we're just going through this quickly tonight because I wanted to hit the highlights. What happens if I, as either your employee or another type of agent, do things that are not authorized by you? Are you liable by them? Boy, that's a good question. Let's talk about that. If I do something that is, way beyond what you've authorized me to do, I may be personally liable, and you might not be liable. Again, there's a lot of factual questions that the judge will look into. But often if I say something to your customer, that's an express warranty. I've represented it as this way. If I've said who the principal is, it's you, and I go ahead and do a contract without your authorization, then I am liable to that person with whom I contracted, not you, because I did it without authority. Okay. I'll let you look at those tests. So I'm liable to other people also for my torts if they're outside my authority. Let's do an example. Let's say this. You might be liable for a tort I commit on a third party, or for my misrepresentation or something I do. What are some examples? Okay. I have had my license revoked, but you still hire me to be a driver at the dock to get passengers from their car to the cruise ship, and I run over people. Well, even though I've done something I'm not authorized to do per se, I did it during the course of activities for which you authorized me, and you sure as heck should have screened me to see if I was a legitimate driver. So you probably would be liable for that tort when I ran over somebody. A school, for example, that hires a child predator without doing a background check. Now, if they had done a background check, here's an example how the rule might give you two different outcomes based on the factual differences. School hires somebody and they're a child predator. Well, if they do the background check and all the references and nothing shows up, and then this vile person goes out and does this horrible thing, then they might not be liable because they took reasonable steps to screen. But let's say this person is has problems with children, and you don't screen them as an employer, or let's go back to Carnival Cruise Lines, for your kids programs, you hire somebody that has had convictions, but you didn't screen them. In that instance, you are likely to be liable for that bad person's misdeeds because you didn't screen them. But if you did screen them, it's a little tougher because someone did a criminal act, even though you did your due diligence. So it's not a yes or no, but you can see the spectrum and the different arguments that make it more likely or less likely that you will be liable for what your agent does. Yeah, you could also be liable, for example, I'm working for you as a tree service. You tell me to go to such and such address. Well, if I cut down a tree on the wrong property, you're going to be liable. You gave me the wrong address. That's another example. I make a misrepresentation to a customer. Well, I say, yeah, this cruise was, I'm selling the cruise and it stops in 3 cities, Italy and Greece. And I tell the customer, it's going to pick you up in California. It's going to take you to London, then to Paris, and then da-da-da-da. But you might not be liable if I wasn't authorized to make those representations. You might say, whoa, wait a minute. Here's our brochure. Here's the contract with Kevin. He's only able to do this sales presentation. He said it was going on. That's not us. That's on him. And the court may well say, yeah, that was outside what authority your agent, Kevin, had to represent you. Now, for employers, it's a lot tougher. Your employers' employees, it's a lot more problematic for you because you're more likely than not to be responsible for what your employee does on the job. So let's talk about scope of employment. Let's look at a video quickly and see what it has to say about that.
The official personal injury attorney sponsor of the Dallas Cowboys. After a car accident, it can often...
In Nevada, employers can sometimes be sued for the wrongful acts of their employees. This occurs in 2 basic situations. The most common is when the employee is simply doing his or her job and an accident injures someone. This is known as the doctrine of respondeat superior, a Latin term that means let the master answer. For example, a cocktail waitress at a Las Vegas casino accidentally spills a drink, and a guest suffers a slip and fall accident on the wet floor and is injured. It is appropriate in this case to let the guest sue the casino or its parent company because serving drink is part of a waitress's job and spilled drinks are a normal and foreseeable risk of the casino business. But let's say the cocktail waitress punches a customer for complaining about bad service. Hitting customers is not part of a server's job. Therefore, in most cases, the casino would not be liable for the customer's injuries. But this brings us to a second situation in which an employer can be held liable for an employee's actions. If the employer itself was negligent in hiring, retaining, or supervising the employer can be held liable for what the employee does. So, let's say our aggressive cocktail waitress had a past conviction for assault and battery, or the casino had received several prior complaints about her abusive behavior, but it ignored them. In that case, the casino may be liable because it knew or should have known that the employee posed a danger to its customers. If you've been injured by an employee...
Okay, that was not intended to be an advertisement for that lawyer, but that's a good example of, or should you be liable for something the employee did? Is it normal? Is it routine? Is it within the scope of their employment? Or have they committed a crime or done something outside their authority? A court will often look on determining whether you, the employer, should be liable for what I did. Was what I did authorized by you? When did it happen? For example, was I on work time? Was the purpose to help the business run? Was it for you, etc.? Do other employees perform the similar acts? Okay, these are the type of things that courts will look at to decide whether you should be liable for what I do. Here's an example that I came up with, and that is you can usually be liable as an employer for things that an employee does on a detour during work, but not a frolic. Okay. I'm your delivery driver now. Okay. So while I'm doing deliveries for you, I stop, pick up a few things at the convenience store. Okay. But while I'm there, I hit a parked car. Well, this is a detour, and believe it or not, it may be likely that you, the employer, are responsible, because technically I was still during the work day, and I was, it's normally seen that I might stop off and pick something up, unless you have very strict rules that I can't do so. Now, alternatively, I get bored one afternoon and I call my buddies and say, hey, let's go get drinks. I've just had it with this delivery. I go pick up my guys in the delivery van and my buddies, and we go watch a ball game and get sloshed, and then I back into somebody in the parking lot. Well, theoretically, you, the employer, should not be liable because I'm on a frolic. I'm not really within the scope of my employment when I do that. Okay. Let's see. Intentional torts. Wow, is a tough one, because you remember the lady that hit the customer? There's no black and white rule, so you're not going to get a test question on this very issue. But some courts will make you liable for my intentional tort. Other courts won't, because they'll say, wait a minute, it's criminal, or it was intentional, and he wasn't authorized to do that. But here's some instances where it can. If you knew or should have known that I had the propensity to commit it, go back to the employee screening and you get the bad guy, then it's likely that you are liable because you should have screened me. Where I'm in very hazardous activities. Again, I'm taking down trees or I'm using dynamite for blasting, then often you can be liable as employer for almost anything that I do on the job. That it's a lot broader. If I commit a crime, you're generally not liable as the employer. I'm your employee, but you're usually not liable unless you participated in it. Now, in some instances, however, you can have criminal liability. Let's think of an example. I work for you, and now you're a power plant, and you generate a lot of toxic waste in your power generation. And in the course of performance, I think, I can save $3 million a year, but I'm just going to dump this into the river that goes by our power plant instead of having the trucks come and treat the hazardous waste. Now, what I've done is a crime, and I'm not authorized to do that. But for example, a federal agency, the EPA, they would probably most likely fine you, not just the employee, for what happened. Again, I know it sounds crazy. We didn't authorize it, but many federal agencies could have civil and sometimes even criminal liability for what your employees do. How do you get rid of an agent? How can you get rid of me? How can you terminate me? Well, you can have a contract that has a definite time. You only hire me for 1 year, then it's over. Or you can just, if you have a right to terminate me, you just terminate me. But keep in mind, after that, I don't have the authority to bind you anymore. I can't sell your tours anymore because I don't have that authority. All right. Now, if I've been dealing with, selling these tours to another travel agency for 10 years, it would be prudent for you to notify that other travel agency that I can't sell anymore. I don't work for you, so that you're not liable for something I say after you have terminated. Let's see. Also, finally, you can terminate me in addition to just the contract runs out, or you have the right to just terminate me. You send me a notice. If either one of us dies or, is incapacitated mentally, if it's impossible, again, the war example, I can't go sell things in Europe because there's a war going on. Significant change circumstances, one of us goes in bankruptcy, etc. These, by law, will terminate the agency, and you'd only have to write a notice of termination. All right, that's it for this lecture, and I will see you next time.